Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what can I do if my child's school district in Connecticut is not following by my child's Section 504 plan?
Hey, Emily, thank you for this question. Now, first, a student qualifies for a Section 504 protection if he or she, one, has a physical or mental impairment which substantially limits one or more of their major life activities, two, has a record of having such impairment, or three, is regarded as having such impairment. Federal law requires public schools to provide services to meet the educational needs of a student with a disability as adequately as a student without a disability. Now, if you have a complaint of a violation of Section 504, it must be addressed to the school or school district involved, not the state. The school districts are also responsible for setting up a system for resolving complaints that meets the federal requirements. Pursuant to federal regulations, a school district or school receiving federal aid must have procedural safeguards that include 1, notice, 2, opportunity for a student's parents to examine relevant records, 3, an impartial hearing with the student's parent having an opportunity to participate and be represented by a lawyer, and 4, a review procedure. The Individuals with Disabilities Education Act, otherwise known as IDEA, dispute resolution system specifically meets Section 504's procedural requirements for dispute resolution. While a few states use their IDEA independent hearing officer systems to also decide Section 504 disputes, Connecticut does not. In a 2009 circular letter from the Education Commissioner to school superintendents, they explicitly stated that the IDEA and 504 due process systems are unique and independent of each other. Although parents of students with disabilities under Section 504 have the right to an impartial hearing concerning the identification, evaluation, or educational placement of a student with a disability, the state does not conduct these hearings, as these hearings are the responsibility of the local school district. The commissioner's letter also emphasized that state mediation, state advisory opinions, and the state due process hearing and complaint resolution procedures are not available to resolve Section 504 complaints. Therefore, in Connecticut, a complaint regarding a Section 504 plan can be filed with the appropriate school district. Pursuant to federal regulations, a school district with more than 15 employees must have both a Section 504 coordinator and a disability discrimination grievance procedure. Additionally, complaints may also be filed with the U.S. Department of Education's Office of Civil Rights, or OCR. The deadline for filing a complaint with OCR is 180 days after the parent first knew of a violation, or if the parent first uses a local school district's grievance procedure, within 60 days after the last action under that process. Now, if you have any questions about your child, you or your child's rights regarding a Section 504 plan, please feel free to give me a call and I'd be happy to discuss your matter with you.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at lmacdonald@mayalaw.com, and please visit mayalaw.com for more information.